questions, and if you have questions, particularly for the professors, if you could speak loudly so that they'll be able to hear you, that would be great. And professors, if you do have difficulty hearing the question, just tell us and we'll have it repeated. Please.
Professor Hill, you talked about the issue of law versus rule. Has there ever been a judicial ruling that has said that a rule is a law?
I couldn't tell you that offhand. What I'm doing is basically trying to make sense of the distinction, and kind of in common, legal terminology, rules often refer to agency rules, whereas law can actually have an incredibly broad meaning. So it very well might include rules. It really depends on the context. What you're talking about. It can include common law. It can include court orders, as we sort of suggested earlier. So, it's unclear, but there seems to be, we're wondering if this distinction between laws and rules was intentional. A court would normally look at that and say, well, they say laws or rules, laws or rules, laws or rules. Then here they say just laws. Most courts would look at that difference within the language and say it must mean something. So that's why I'm suggesting that maybe that's how a court would read it, if that makes sense. In other words, courts would assume there would be a reason for saying only laws in one area.
Great, thank you. Other questions?
Who signed off on the language for this? Was it Cordray, or did he certify that?
Who signed off on the language? So I'm assuming they collected signatures starting in 2010. So I assume, yeah, it was under the previous Attorney General. Was
Cordray wrong to certify that language?
Oh, I don't think this is about the language in the certifications. It's the meaning of the language. I mean, you can get, as you know, anything you want on the ballot. I think it's not a problem of certification. It's a problem of how it was drafted and the far-reaching effects. Professors, would you agree this isn't about certification? It's about the language in and of itself. And maybe the question would be who's behind the drafting of the language, which I think is probably a little more relevant question to dealing with these unintended consequences, or maybe, quite frankly, some intended consequences that that these groups would support. So, for example, we know that supporters and those who have drafted this language include the 1851 Center for Constitutional Law. We actually provided some of their materials in the back so you can see how they talk about this. A lot of people who are involved in the Tea Party around the state are behind this, the Liberty Council. And so that, to my understanding, those are some of the names that were associated with the drafting of the constitutional amendment and supporting the constitutional amendment as well.
Professors, if the folks who drafted this wind up telling us, look, if the basic law, like the creation of workers' comp, happened before 2010, and it obviously did, then our proposal doesn't impact rules that are used later to tweak that law, so don't worry about it. What would you say to, what can you point to in the amendment that says, no, that's not the right interpretation?
Well, the problem is that the drafters of this amendment don't get to tell us what it means. The courts get to tell the citizens of Ohio what this means. And, as we teach this to our students and how to draft language so that it's absolute, so that if you want it to be clear, it is clear, this would be the kind of language that would raise real ambiguities for the courts. You have to think specifically. So think of some development that given the political complexion, say, of the Ohio Supreme Court at the time, was something that a majority of the justices were not in favor of. They might well use this sloppy language to interpret this amendment very broadly or narrowly, whichever way it cuts. You can't be sure how this is going to play out just because the proponents tell us how they wish they could have drafted it more clearly.